Hey there, my friends! Welcome to those of you watching us for the first time. And to those of you already sharing this journey with the Academy, thank you so much for joining me again. Here, we're exploring international law. The two playlists mentioned above are the paths that we have took so far, and I am here to take it further by drawing the law alive. So far, I've uncovered the first element of a state, territory, which you can revisit in my playlist above. And today, we're turning the page to the second element, population. Ready your curiosity, and let's begin this new chapter together. When we speak about the elements of a state, population is where it all begins, the human core around which the idea of sovereignty takes shape. When we look at the world map and trace the outlines of states, behind every border there is not just soil. There are lives, memories, and belonging. Territory gives a state its shape, but it is the people who give it a soul. A state, after all, is not just territory and authority. It is a community of people bound together by law, by belonging, and by the invisible threads of shared existence. But what do we really mean by population in international law? Scholars have long debated this. Some view it from a subjective or personal perspective, rooted in the principle of self-determination. According to this view, a population is formed by those individuals who, through their own will and sense of attachment, choose to belong to a political community. People who identify themselves as part of a nation through shared purpose and mutual consent. In this light, the people of a state are not merely those who reside within its borders, but those who feel and claim that identity. Others, especially within the objective school, influenced by the German doctrine of nationality, emphasize concrete and enduring elements: race, culture, language, and historical continuity. For them, the population is defined not by will, but by the factual existence of a human group united by stable and recognizable characteristics. It is a sociological and biological understanding rather than a purely political one. Between these two approaches, international law has gradually shaped a balanced concept. A population, in the legal sense, is the permanent community of persons living under the authority of a state and linked to it through nationality. They may differ in language, ethnicity, or faith, yet what unites them is a common legal and political bond that ties their destiny to that of the state itself. This bond is expressed through nationality, which serves as the legal thread between individual and state. It carries both rights and duties: protection abroad, obedience to national law, and participation in the life of the community. When we say population, we don't just mean a number. We're talking about the living mosaic of people, those who share a homeland, yet not always the same story. In every state, there's a majority, the main rhythm of the nation's voice. Beside them live minorities, different in language, belief, or heritage, but threads of the same fabric, adding depth and color to the whole. And then there are the Indigenous peoples, the original custodians of the land, whose memory stretches beyond the borders drawn by law. They are the roots beneath the soil of identity. Together, these groups form the population, not a uniform mass, but a living harmony where law, culture, and history intertwine to give the state its human soul. When we speak of the majority, we mean the larger body of people who shape the common rhythm of a state. The dominant language that fills its streets, the traditions most often celebrated, the values that quietly guide its politics. They are not superior by law, but they often define the tone of national life, the way a melody carries the harmony beneath it. The majority gives a state its cultural face, the shared sense of belonging that most citizens recognize as home. Speaking of a population, we must also consider its colors, and those hues are carried by minorities. The majority gives rhythm, but the minorities bring depth and harmony. From the very beginning, law understood that a state's strength depends not on sameness, but on how it treats those who are different. The idea of minorities first took shape in the 19th century, in the Hungarian parliament, a recognition that within every nation, some voices stand smaller in number, yet carry equal worth. In the early 20th century, the League of Nations began protecting these smaller communities through treaties and declarations on national, linguistic, and religious minorities. Though those early efforts faded with time, their spirit lived on. In 1992, the UN General Assembly adopted the Declaration on the Rights of Persons Belonging to National or Ethnic, Religious, and Linguistic Minorities. A document of 9 articles affirming that every state must ensure equality, protect identity, and enable participation in cultural, religious, and public life. Minorities, under Article 27 of the International Covenant on Civil and Political Rights, are entitled to both individual and collective rights, the right to speak their language, to worship freely, to preserve their traditions. The Human Rights Committee even extended this protection to groups, recognizing that the dignity of difference is part of humanity's shared heritage. History, however, reminds us that progress is uneven. Treaties like Westphalia, Rye, and Berlin once accepted religious, racial, and linguistic discrimination, lessons that law later sought to undo. Today, minorities are not exceptions to the state. They are the test of its conscience, where they are free to live, speak, and believe without fear. Law is alive. And finally, let's turn to the oldest voice within the population, the Indigenous peoples. They are not just a part of the state. They are the roots beneath its soil. Indigenous communities are those whose lands were overtaken through colonization, whose histories began long before borders were drawn or flags were raised. They carry memories older than the state itself, of rivers, mountains, and sacred grounds that shaped their identity and law long before modern sovereignty was spoken of. For centuries, their existence was shadowed by conquest and silence. But in 2007, the world finally paused to listen. The United Nations Declaration on the Rights of Indigenous Peoples, UNDRIP, became their charter of dignity, affirming their rights to land, culture, language, and self-determination. This declaration recognizes that Indigenous peoples have the right to govern their affairs, to preserve their traditions, and to maintain spiritual ties to their ancestral territories. To ensure these rights are respected, international bodies began to form under the guidance of the Economic and Social Council, ECOSOC, and the Human Rights Commission, later the Human Rights Council. Among them stands the Permanent Forum on Indigenous Issues, UNPFII, which advises the UN system on Indigenous concerns, the Special Rapporteur on the Rights of Indigenous Peoples, who monitors and reports on their situation worldwide, and the Expert Mechanism on the Rights of Indigenous Peoples, MRIP, created to provide studies and guidance to governments and the Council itself. These mechanisms, born from ECOSOC's and the Council's work, represent the institutional heartbeat of the Indigenous rights movement, reminding states that moral recognition must be matched with practical accountability. It is not a treaty, but a moral compass, guiding states to respect the voices of those who have kept humanity's first relationship with nature alive. The Declaration stands on 4 pillars: self-determination, cultural integrity, non-discrimination, and consultation. Together, they form a quiet but powerful reminder that progress without memory is not justice. So, when we study population as an element of the state, we must not forget that among citizens and minorities live the original guardians of the earth, those who remind law that belonging begins with respect. I actually like this drawing very much, don't you? Okay, we have covered the key information about population, but remember, when we speak of a state's population, we are not counting heads. We are tracing continuity. A people is not defined by its number, but by its permanence. A stable community that endures through time, rooted in the land, carrying a shared legal and social identity. This permanence distinguishes a state from transient settlements or temporary occupations. Even when migration, exile, or displacement occur, the legal personality of the people remains, the thread that keeps the state alive across generations. Yet what truly binds individuals to the state is more than geography. It is nationality, the legal bond of belonging. Through nationality, the individual becomes a participant in the legal life of the state, and the state assumes responsibility for their protection and representation. This bond defines both rights and duties, allegiance from the individual and protection from the state, creating a reciprocal circle that sustains sovereignty's human foundation. But in today's world, this circle is not complete for all. Millions remain stateless, persons without a recognized nationality, living between borders and laws, belonging everywhere and nowhere at once. Their existence reminds us that population, though essential to statehood, is also fragile, a concept of law that struggles to contain the movement and complexity of human life. And so when we define population as an element of the state, we are defining more than a number. We are defining continuity, belonging, and protection, the living link between territory, people, and law. It is this link that gives a state its human face and international law its moral depth. Okay, thank you so much for accompanying IntlLaw, my friends. I really enjoy drawing the law alive with you. In our next videos, we will cover the last elements of state and international law. So remember to come back and keep your pencils sharp. See you soon.